The tribunal is now in session. President Wall and the Honorable Tribunal members Petit and Prost presiding. The case before the court is a matter of the Government of Canada versus the Government of the United States. The applicant and the respondent are each alleged. You may now sit.
Counsel for the appellant?
Yes.
You're ready if you are.
Good afternoon, Madam President, Your Excellencies. May it please the Court, I am James Van Wyk, and along with my co-agent, Mr. Justin Dick, I'm appearing before you today on behalf of the applicant, the Government of the United States of America. The applicants have reserved 3 minutes for rebuttal time. Before proceeding with submissions, would the Court like a recitation of the facts? Briefly, the island of Tangoon is located in the southern Pacific Ocean. It is the home of 2 states, the state of Tangoon and the state of Sumatra. On May 25th, 2011, tropical cyclone Kodo struck the island of Tangoon and inflicted much more damage on the state of Tangoon than on its neighboring country, Sumatra. In the aftermath of the cyclone, the government of Tangoon, as a result of its religious views, refused to accept any offers of humanitarian aid from the international community. And this led Canada to intervene, break through Tangoon's border wall, and provide aid as it saw fit. The United States submits that Canada's intervention into Tangoon was unlawful, as was its apprehension, detention, and proposed surrender to the International Criminal Court of both Mr. Ishmael Balthazar and Mr. Clyde Barrett. I will be addressing the issues surrounding Canada's actual intervention, and my co-agent will then discuss the issues surrounding Canada's treatment of the 2 members.
On a preliminary basis, counsel, what relief are you asking from this court?
The United States is looking for the court to reprimand Canada for its intervention and additionally to request or to rule in the immediate release of both Mr. Ishmael Balthazar, the de facto head of state of Tangoon, and Mr. Clyde Barrett, an American citizen. Your Excellencies, the United States would like to begin by reiterating that its sympathies are with the people of Tangoon, who have suffered a terrible tragedy. Tragedy is not, however, a license to disregard the law. If Canada's actions are to be found lawful, a very dangerous precedent will have been set. At its root, this is a case concerning the violation of the foundational concepts of international law, the importance of territorial sovereignty, and the prohibition on the use of force. Both of these concepts are alluded to in the very first article of the United Nations Charter, which outlines the principles and purposes for which the organization stands. The submissions to follow will first show how Canada has in fact violated international law. We will then show how none of the narrow established exceptions to these violations are presently applicable. This will involve an examination of collective self-defense, the nascent responsibility to protect doctrine, and the General Assembly's Uniting for Peace powers.
Is it your contention, counsel, that there was nothing that no outside country could do in the situation where they were affected by Tangoon's inadequate response to the flood?
It is the submission of the United States that while this type of case could present a situation where intervention is possible, the way that the international community has responded to it created a scenario where no state could have intervened unless the proper procedures had been followed for the narrow exceptions to the prohibition on use of force.
Let me just pursue that once. No. Suppose you had a situation where one country had an epidemic of bird flu and there was a world pandemic threatened by it, and that country refused to take the steps that could stop it in its own country. Would your answer be the same, that nobody could do anything if they didn't go through?
Again, with respect, Madam President, it is the submission of the United States that there are procedures in place to violate the very foundational concept of territorial sovereignty. And I again just like to draw a distinction between this hypothetical and the case now of a natural disaster on 2 states. It's not a worldwide pandemic, and it is a slightly narrower than the example you provided. And I'm going to...
Why would the slightly narrower results make a change in international laws to the procedures that had to be followed?
While I don't think that it would make a change to the laws that would have to be followed, the laws are consistent and would be consistent in any situation. I believe it would change the international community's reaction, and this would thus allow the laws to be carried out in a different manner. And so I'm going to skip past my first submission, which you can find in the first 2 pages of the applicant's memorial, and that is that force has been used and sovereignty has been infringed upon. Canada does not deny this. They simply seek to justify their actions through the exceptions I alluded to. And so the first exception I would like to discuss is that of collective self-defense. And this can be found, firstly, in Article 51 of the United Nations Charter. This provision in the Charter states that nothing in the present Charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a United Nations member state until the Security Council has taken the appropriate measures to maintain international peace and security. With this doctrine, whether customary or international law, this court has stated in the Niagara case that there are preconditions that must be met if appropriate self-defense is to be legally justified. The first precondition is that of, directly from the language of Article 51, is that of an armed attack. The second two, while relating more to the customary international law conception of self-defense, again, were stated in this court in Nicaragua, and that is a requirement of necessity and proportionality with regard to the armed attack that has been alleged. So I'd first like to illustrate how no armed attack has been committed by Tangoon capable of allowing Canada to act in collective self-defense. And while there is no concrete definition of an armed attack in international law, there are certainly sources that can help us to interpret this term. One such source that the United States would like to point to is General Assembly Resolution 3314, which defines acts of aggression. It states that an act of aggression, that an armed attack is a subset of an act of aggression, and it goes on to list a number of situations which could be considered acts of aggression. The United States submits that the situation in Tangoon does not meet any of these situations on that list, and that furthermore, while that list is not exhaustive, the provision explicitly states that it's the Security Council that is vested with the sole authority to further determine what an act of aggression is. Presently, the Security Council has not stated that anything that has taken place in Tangoon can be considered an act of aggression.
Counsel, isn't it the position of Canada that it had the imprimatur basically of the General Assembly to act, and that was sufficient enough because of the non-action of the Security Council?
Yes, and this moves me into my final submission, which I can get to now for you, Your Excellency, and that is I think you're alluding to the concept of the Uniting for Peace resolution that the General Assembly has from Resolution 377V, and this was established in 1950 in response to the war in Korea. Now, there are a couple issues that the United States would take with these submissions of the respondents.
And yet you're relying, excuse me for interrupting, but you're relying on the General Assembly's definition of armed attack at the same time.
Oh, certainly. Getting back to an act of aggression, Your Excellency, the reason I am relying on that is because there is no clear definition in international law of what an armed attack is. And while the United States does not submit that this General Assembly Resolution 3314 is binding on this court, it does submit that it is persuasive, and it illustrates a sense of a customary international law sense of what armed attacks are considered to be. And this much was stated by this court in the Nicaragua decision.
Isn't there quite a body of law, though, under the Crimes Against Humanity about the definition of what an attack is, and shouldn't that inspire us?
Sorry, Your Excellency, I missed that.
Isn't there an important body of law defining what an attack is in terms of an element of Crimes Against Humanity?
Certainly, I again believe you're referring to with Crimes Against Humanity, the need for a widespread or systematic attack. But ignoring the attack requirement, the United States would submit that the key point with armed attack is the armed nature of it. And there was nothing armed about the attack that was alleged to have been committed by Tangoon.
So you would narrow it down to the use of weapons and not anything else?
Not solely the use of weapons, but the use of weapons is actually one of the enumerated actions that is referred to in the General Assembly Resolution 3314 capable of being considered an armed attack.
What about counsel? What if one country explodes a nuclear bomb such that the radiation goes over into its neighbors in a fairly intense way that certainly would be recognized as a cause of potential harm? That's not an armed attack, and if the Security Council decides to do nothing about it, just too bad?
With respect, Madam President, the distinction I'd like to draw between that example and the present case is that of intent. And in your example, it seems to me that one country has intentionally detonated and intentionally used a weapon. The government...
Well, suppose it was an accident. It was North Korea or something. I'm just using it as a hypothetical, obviously. And it blew up, and it poured radiation over into South Korea, but then North Korea did nothing about trying to alleviate, any of the harm that was caused by it. And the Security Council just sat there because it had a veto, because Russia or China or somebody else had a veto. Then, too bad? There's just nothing that can be done under international law?
The United States again submits that there is an intent requirement for the armed attack. There must be an actual use of a weapon. And so getting back to our case, there was no use of a weapon by the government of Tangoon. There was an unintentional spread of pathogens from one country to another.
Yeah, but they, apart from the intent to use it, if there's no follow-up by the country to try to alleviate the damage that's being caused to its neighbors, that's not good enough?
The United States submits that there is no duty to prevent the spread of pollution to a neighboring country capable of allowing for the infringement of sovereignty or criminal repercussions. Well, there has been cases such as the Trail Smelter case where pollution has been used as an example. In a civil suit, there is no such example from a criminal standpoint. And moving on to the second submission briefly regarding collective self-defense, the United States would like to just point to the second of the three required elements. I will not be dealing with proportionality today, but that is that of necessity. And the United States, as was interpreted again in the Nicaragua case, submits that necessity implies that all peaceful means have been exhausted. And in the present situation, Canada has not exhausted all peaceful means specifically regarding the prevention of the spread of disease, which is the alleged armed attack.
What has it not done?
A few possible alternative scenarios could be some type of filtering of the water system. This is the water, the rivers are what's carrying the disease into Sumatra. Filtering and damming. There's an abundance of aid that has been provided to Sumatra, just waiting to get into Tangoon, food and water. That can be distributed to the people of Sumatra while the
But as I understand the record, the government, Tangoon, wouldn't let any people come in there to try to help the people or to try to provide aid if they won't do that. So what could they have done?
Well, with regards to collective self-defense, stopping any crimes that may have been happening in Tangoon is presently irrelevant. It just has to do with stopping any harmful actions that may have been happening in Sumatra.
But that's not very practical. If you have a river that keeps going through both countries, you got to stop it someplace. You can't. I don't know. What do? They set up some kind of a barricade at the point of the national boundary?
Respectfully, the United States simply submits that this wouldn't be a permanent solution. It would just be a solution to stop the spread of disease while more peaceful means are used, such as negotiating.
As I understand, and Sumatra wouldn't talk
With respect, Madam President, one communique was delivered to the border wall. If we look into a very similar situation, the 2008 cyclone in Myanmar, there were and the sovereignty was never infringed upon. In the interest of time, I'd like to move to my third submission. That relates to the responsibility to protect doctrine. Now this submission of the United States has not reached the level of any of the accepted sources of international law that this court is bound to follow. It is not treaty law. It is not a generally accepted principle of law. There is no consensus among judicial decisions or the work of scholars. And the final source is customary international law. The United States submits it has not reached this level of customary international law, both because of a lack of state practice and a lack of opinio juris, or a sense of legal obligation. In the alternative, the United States further submits that even if this court were to find that responsibility to protect doctrine had reached the level of customary international law, There are strict procedures which it must be carried out in accordance with. What I'm alluding to here is the requirement for Security Council approval, and again, similar to our necessity requirement for collective self-defense, the requirement that all peaceful means be exhausted, and the language for both of those comes from the World Summit Outcome document where...
Counsel, I want to be very clear in this position, you advocating for the United States are saying that no matter what the circumstances, no matter what the activity may be within a country aimed at its own population or another population, unless the Security Council can authorize the action, there's no ability for intervention to protect those civilians? That's the position of the United States?
No, Your Excellency, the position of the United States, and sorry, let me clarify myself, is that there certainly are situations where that type of intervention is possible. This simply is not one of them.
And what distinguishes this particular situation from others that would allow for the responsibility to protect?
Well, if we look at the limited state practice that does exist with regards to responsibility to protect, we can look at situations like Libya last year, or even today what is happening in Syria. And these are situations where a government is actively using arms against the citizens of its own country. And again, I would draw the distinction, and although it may be a small distinction between omissions and commissions, it is a very important distinction nonetheless. Presently, Tangoon...
There isn't for the victims, though.
With respect, Your Excellency, you're correct. There is no different for the victims.
And so if all the boxes are not ticked, we just let the people die?
Well, I understand the moral hazard of this statement, Your Excellency. International law, and that is the law this court is bound by, states that you need to have established one of the four sources under Article 38(1) of this court statute. The United States would submit that the use of the veto is both treaty laws. It is contained in Article 27(3) of the United Nations Charter, and it has reached the level of customary international law. There's been repeated state practice, and nations clearly feel bad.
US itself, the United States itself, has participated in attacks that didn't have Security Council approval during the Balkan Wars.
And again, with respect, Madam President, I understand the hypocrisy that you're drawing out here. That these again are fundamentally different situations from that which we're presently dealing with, which is the aftermath of a natural disaster where a country without any legal support has broke through a border wall, engaged in a firefight, and apprehended, detained two individuals that they have no right to do so.
But I understand the purpose, at least I didn't see it disputed in the record, the purpose of the Canadian expedition was to humanitarian in nature, was to provide aid and also to try to a purpose. It was not an expedition to capture territory or to gun down any of the okay.
Well, just with respect to time, Madam President, and while this was the stated purpose of Canada, we have to look at what actually happened when they were there. They exploded a border wall, they stated. They broke through a blockade of Tangoon security personnel. They engaged in a firefight and killed 10 Tangoon security personnel, and have now apprehended and detained two individuals who, as my co-agent will demonstrate, they had no justification to do so. This court has stated in its advisory opinion on the use of nuclear weapons that the very basis of international law rests on the principles of sovereignty and consent. The United States respectfully requests that the court stand by that proclamation. If there are no further questions, I would like to
have any
know.
further questions? Go ahead, Counsel.
Good afternoon, Madam President. May it please the Court, my name is Justin Dick, co-agent for the applicant, the Government of the United States. This Court has heard the arguments of my co-agent, Mr. Van Wyk, who submits that Canada's intervention into Tangoon violates the foundational principle of international law, that is, respect for national sovereignty. As this court will see, this violation was the first in a pattern of Canadian disregard for established norms and principles of international law. In particular, Canada's apprehension, detention, and proposed surrender to the International Criminal Court, or ICC, of an American citizen, Mr. Clyde Barrett, and a citizen of Tangoon, Mr. Ishmael Balthazar, are in clear violation of international law. The arguments to follow will first establish over either Mr. Barrett or Mr. Balthazar is an unjustified overextension of the ICC's prescribed reach as outlined in the Rome Statute. Subsequently, my arguments will shift to consider the individuals in question and the particular circumstances surrounding their apprehension and detention. It will be demonstrated that even in the unlikely event that the ICC could claim is protected by head of state immunity, and there is no legal basis for apprehending or detaining Clyde Barrett. Thus, I would direct the court, if you do wish, to follow the arguments that correspond in the memorial. They can be found on the bottom of page 10 of the applicant's submissions. Overarching factor that the ICC has no jurisdiction over either individual in question. Your Excellencies, ICC jurisdiction is outlined by Article 12 of the Rome Statute. This provision states that the court has jurisdiction over the nationals of state parties to the Rome Statute, so citizens of those countries who have ratified the statute, and over of state parties. Canada's proposed surrender of the two men lacks justification on either grounds. Both men are citizens of countries that are non-state parties to the Rome Statute, and as such, the only legal basis for the transfer of these two men would have required that the alleged crimes took place within the borders of a state party.
Isn't that what happened here? I mean, at least the allegations of the Canada are that indeed when refused to do anything that was effective in stopping the pollution, and it just continued, it ran over into the other country, it therefore injured seriously the citizens of the other country and effectively committed a wrong. Why is that wrong? Why is that a bad analysis?
It's not a bad analysis. I understand the question, Madam President. Your question brings up the point of effects doctrine. It's a means of interpreting the territorial jurisdiction of the ICC that states that, that would posit that when an action bleeds over onto that of a non-state party, that perhaps this doctrine could be used to validly enact the ICC's jurisdiction. It is the applicant's submission statute on the concept of a fixed jurisdiction must be taken very seriously by this court. It is a principle of treaty interpretation codified in Article 31 of the Vienna Convention on the Law of Treaties that dictates that a treaty shall be interpreted in good faith with ordinary meaning to be given to the terms of the treaty. When the drafters of the Rome Statute were debating what should and should not be included in the Rome Statute, they did so with much time considering the implications of their decisions, and effects jurisdiction was left out. Madam President, your question, even if we were to accept that effects jurisdiction the ICC's reach in this case, the effects felt in the state party, Sumatra in this case, would have to amount to one of the 4 core crimes of the Rome Statute for the ICC to operate here. Now, at this time, it certainly has not. That is the applicant's position.
What about crimes against humanity? That would be the most natural.
Madam President, on the facts, we know that there is some people in Sumatra are sick. There has not been at this time a single death attributed to the terrible cyclone which struck the island. So the ICC's attempt to extend its jurisdiction based on effects doctrine, which was...
Quote the Rome Statute, excuse me for interrupting. Crimes against humanity has at the bottom call it a catch-all if you will, other humane acts of a similar character intentionally causing great suffering or serious injury to the physical or mental health of the people in that other country. I don't think it says you have to have a string of deaths.
No, it does not say that, Madam President. You are correct. I was simply stating that there had not been a death as an example that the claim that a crime against humanity has been committed against Tangoon is arguable, and against Sumatra it is even more tenuous. And first of all, effects jurisdiction being excluded by the drafters, and second of all, there being tenuous grounds at best for establishing that a crime against humanity has been committed within the territory of a state party. It is the applicant's submission that the ICC cannot validly claim jurisdiction here.
So, counsel, are you...
That is not the applicant's position. The applicant's primary submission, Your Excellency, is that the silence of the Rome Statute on effects jurisdiction, its deliberate exclusion from the final document, should be given a strict construction and not be extended that far. I would urge the court to consider the consequences of effects jurisdiction being implemented in cases like this for the ability of countries around the world to predict the consequences that their actions would have.
Counsel, are you saying that there would be a difference if this had been a different kind of act? For example, if someone were to stand on the border between Canada and the United States and set off a chemical weapon that reached far into the United States, are you saying that that could be governed by the effects doctrine, even though the weapon was set off in Canada? Is that what you're defining this by, the nature of the act?
Well, Your Excellency, that in that case obviously is quite different from the facts that we do have before us today. It would be consistent with the principle from the Lotus case that yes, in that case, when such a dramatic effect has a clear transboundary nature, that yes, perhaps that could
that would be the effects doctrine nonetheless. So I'm trying to understand the distinction that you're drawing between that act and what we have before us here. In my view, the doctrine either applies or it doesn't. It
would be the applicant's submission that it does not apply. That perhaps under national courts, where the Lotus principle has been relied upon exclusively, there could be an avenue to pursue such a claim there. Within the confines of the Rome Statute and in the provisions outlined there before this court today, it is the...
So you're really suggesting that if, let's take an extreme example, but just to pursue my colleague's point, if somebody intentionally set off in one country a bomb or a terrible biological warfare, which quickly spread over many countries, over a whole continent, ended up with all kinds of deaths, all kinds of terrible situations. Still, and the person, the single individual who was responsible for making that decision was attempted to be indicted not indicted, but an arrest warrant sought by the ICC.
And in that particular circumstance, you could argue certainly that there is a crime against humanity.
Why is it different, as my colleague suggested?
The primary reason it's different, Your Excellencies, is that there has been no core crime of the ICC committed on the territory of a state party to the Rome Statute.
Because I'm having trouble seeing what the difference is there.
I apologize, Madam President, but it is the applicant's submission, and in the interest of time, perhaps I will proceed after this statement, that upon the territory of Sumatra, where people are sick, I believe it's 300 people have come down with the sickness, that is a tenuous claim for a crime against humanity. And similarly, the concept of universal jurisdiction is further argued by some that it should apply to the ICC and to the Rome Statute. And it is the United States submission today that there is no legal basis for a court that can exercise jurisdiction over any citizen, and jurisdiction is the most contentious basis of establishing jurisdiction in international law. And the United States submits that that countries accepted an ICC without universal jurisdiction precisely because Article 12 represents a reasonable compromise between furthering justice while respecting national sovereignty and norms of customary international law. The applicant's submission analyzing the circumstances surrounding the apprehension and detention of the two individuals that we're dealing with today. Firstly, the United States submits that Canada's detention and proposed surrender of Ishmael Balthazar is in contravention of the norm of head of state immunity and also in its contravention of the Geneva Conventions.
Counsel, correct me if I'm wrong, but who is the head of state?
Certainly, Your Excellency. While the official head of state title does rest with Rafiki Balthazar,
So he is the head of state?
Yes, he is the head of state, and the applicant would like to point out that international jurisprudence on this point, really head of state immunity is mischaracterized in the sense that what the United States is dealing with that is afforded to individuals who are entrusted to represent their state and in the international arena. And it is the applicant's submission, I apologize, Your Excellency.
No, go ahead.
Oh, sorry. That it is the United States position today that Ishmael Balthazar does regularly represent his state at the international level. There's an example of this on the facts, Your Excellencies, when Canada delivered a communique to the border wall, the official government response in the wake of the disaster.
So I'm sorry.
No, go ahead.
So while interpreting one argument or the lack, for example, in terms of the jurisdiction of the ICC, you are supporting a very narrow interpretation. On this side of the argument, you're supporting a very large interpretation, and that's simply showing up at some conferences or representing the country abroad. You are the de facto, or at least, is that what you're saying?
Well, with respect to Your Excellency, in this particular case, Ishmael Balthazar is the de facto head of the military and the government. He's a person of obviously, upon the facts, a person of enormous influence within his country.
Do you have any authority from us, the ICJ, to that effect, recognizing de facto heads that went below the foreign minister? And certainly the ICC itself doesn't recognize immunity.
That's quite right. To answer the first part of your question, well, in the arrest warrants case, the individual in question was a foreign minister. In that case, it stated that top government officials, diplomats, for example, those entrusted to represent their state in the international arena, that personal immunity afforded to heads of state should be afforded to them because the purposes of the immunity are the same for both parties.
But Counsel, given the Rome Statute's provisions about the state immunity being inapplicable, why is this relevant? Why is this relevant in terms of the International Criminal Court? This isn't turning him over to another country.
So you're quite right, Your Excellency. Article 27 prohibits that any individual from invoking immunity when brought before the International Criminal Court. It is the applicant's submission today that this is an incomplete understanding of the functionality of personal immunity before the ICC. Article 27 must be read in conjunction with Article 98. Article 98 states that the ICC may not proceed with a request for surrender or assistance which would require the requested state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person of a third state, in this case, Tangoon, unless the court can first obtain the cooperation of that third state for the waiver of immunity.
Isn't it, Counsel, am I not correct? I should know, but I'm asking you to inform me that we, the ICJ, held in a prior case, sorry to say the name escaping me at the moment, that while heads of state immunity, acting heads of state do have immunity under international law, it did not rule, and a couple of the members of our court specifically talked about it in separate opinions, did not rule as to whether or not that particular heads of immunity, which was recognized, applied to international.
Certainly, Madam President, and there are examples in international jurisprudence, including cases before the International Criminal Tribunal in Rwanda and in the former Republic of Yugoslavia, where individuals with immunity have been tried before international courts. The critical distinction that the court must make today is that in both of those courts that I mentioned, as well as other examples, UN Security Council referral is the key element that gives the court the authority to override certain provisions, such as head of state immunity. Now, the ICC and the Rome Statute, this is a treaty-based court, Your Excellencies. Countries can choose to ratify it or to not ratify it. And for Article 27 to apply to all individuals, and effectively that would strip Article 98 of all substantive content. And that is an element contrary to the principles of treaty. I'm sorry, Your Excellency.
Yeah, Counsel. I think Article 98 has a much broader reach if you examine it than just the question of state immunity. It applies to searches where the diplomatic immunity might kick in. But more to the point before us, what if this situation was referred by the Security Council? Are you saying then that state immunity, that Article 27 governs, but only where the Security Council has referred the situation?
That, Your Excellency, which has been debated extensively by the scholarly community.
And I appreciate hearing your position on it and the United States position on it.
It is the United States position that UN Security Council referral would not waive the immunity, even if this court chooses to reject that assertion. There has been no UN Security Council referral in this case, and that is the most influential factor for the decision on immunity today.
If the referral didn't affect immunity, then that would pretty well eliminate any reliance on Article 27, and the body would never be delivered. Is that the case?
Could you expand on the question here?
You're saying that state immunity, in the case where state immunity is applicable, if the referral has no effect, then you're never going to get the body delivered because state immunity is going to continue to be relied upon. That's the
referral can have that effect, and it may. It is the United States position today that it does not. And in the interest of time, I apologize, Your Excellency. May I briefly touch upon Mr. Clyde Barrett, just quite briefly in the interest of time, and then move into a conclusion?
All right. You may do it
Okay. Thank you, Madam President. So with regards very quickly to Mr. Barrett, the applicant would like to re-emphasize that the court, that the ICC has no jurisdiction over an American citizen residing in Tangoon for commercial purposes. Even if this were not the case, the information contained within the diary is essential to the charge against him, and this diary was unlawfully dispossessed of Mr. Balthazar in a violation of Article 18 of the Third Geneva Conventions on the Treatment of Prisoners of War. And since I do not have time to unfold that dialogue in full today,
I'll help you out by asking a question.
Okay.
Okay. And same for my colleagues if they have a particular question on this issue. Does it make any difference to this argument about Mr. Barrett's the legitimization of his arrest as to whether or not the whole intervention, your colleague's argument, the whole intervention was in fact illegal? Because suppose it was a humanitarian intervention that was, I know that's not your position, but that was legal and was authorized. Then would not Mr. Barrett's arrest under these circumstances, or why would not Mr. Barrett's arrest under these circumstances?
well, Madam President, your question raises the issue of malacaptus, bene detentis, I believe, wrongly captured, properly detained. For that doctrine to be evoked, the court which seeks to rule over the individual must have jurisdiction. And since the ICC has no jurisdiction, it is the applicant's position that the ICC has no jurisdiction over an American citizen, so that this doctrine cannot be successfully invoked.
But as I understand Canada's many arguments, and we'll get to those when they come up to bat, but that one of their arguments is that at the point at which Mr. Barrett was apprehended, they were trying to prevent basic human rights violation from being committed. Leave out the ICC for a minute.
Okay.
They were there on a legitimate purpose, and so therefore he was obstructing, or he was the person responsible for the human rights violation, so therefore they had a right to apprehend him.
Are you specifically referring to the accusations of slavery?
Yeah.
Well, it would be the applicant's submission to address that, Madam President, that what was happening in Tangoon was the use of a national service program. While yes, certainly the working conditions in this very poor country may be different than those that we are used to in the United States and in Canada, it would be reckless of the court, in the applicant's opinion, to impart our standards on a country with such vastly different socioeconomic structures. While there is no evidence, Madam President, to briefly wrap up, since I apologize, I'm so far over time, that Clyde Barrett had any real knowledge or control over the national service program, which was a part of the civil obligations of that state, similar to how countries may enact a military draft.
Let me ask my colleagues if they have any further questions. Okay, thank you.
Okay, so we respectfully request the immediate release of Mr. Balthasar and Mr. Barrett and a public reprimand of Canada's behavior. Thank you, Your Excellencies.
Myanmar, we had a situation that was very much analogous to this case. However, in that case, aid was accepted. Distinguishing that case from here, aid was affirmatively rejected in all cases.
So is it Canada's position, Council, for example, that if a native population in Canada was being harmed by pollutants, let's say mercury in an hypothesis, and would be doing, and the Canadian government would be refusing to intervene, or according to the U.S. anyways, to intervene, then the U.S. would be legit.
If it was a case where there has been the committal of gross human rights violations,
would you consider poisoning children?
well, it depends if it's been elevated to a crime against humanity. So for
Yeah, and where's that threshold?
the crime against humanity, well, if you have the definition of a crime against humanity is
No, in that particular fact that I'm giving you, in that particular fact situation that I'm giving you,
yes.
in terms of, as I said, a native population being poisoned by mercury, with the full knowledge of the government of Canada, and without proper intervention to minimize that, would then that amount to a crime against humanity, according to you?
Yes, it actually could, specifically the crime of extermination, when a perpetrator kills one or more persons with knowledge that this condition was part of such an attack.
So
If the Canadian government, if pursuant to the responsibility to protect doctrine, if the Canadian government has failed to protect their civilians, the United States can then perhaps request a session at the Security Council, passing a resolution that can authorize an intervention so that the United States can invoke their responsibility to protect. If the Security Council fails, alternative actions can be used with the General Assembly uniting for peace. And
I'm interested in that point, Council, and I know Canada's always been very keen on the responsibility to protect doctrine. But isn't it the case that it's envisaged to be a doctrine applicable through the Security Council? That's the balance here, that the intervention of the Council is what gives some balance, let's put it that way. And in this case, that doesn't exist. So where do you draw from in the argument that it was sufficient to have a General Assembly?
with respect, Your Excellency, the reason why the Canadian government had actually initiated the responsibility to protect doctrine was because of the failures of humanitarian intervention. So to answer your question, if Because in the face of a veto, we have an extreme threat to international peace and security. And because of this reason, nations would intervene without any form of authorization. So the responsibility to protect doctrine, specifically implementing the responsibility to protect, the Secretary General has stated that if the Security Council has failed to uphold its international peace primary but not secondary, not exclusive, but primary obligation to protect international peace and security, alternative measures can include going to the General Assembly to invoke their Uniting for Peace authority.
But you would agree, Counsel, this is a new extension of the R2P doctrine to approach it. You're asking us to sort of make it up. Do you agree with that?
I would agree. However, the Uniting for Peace resolution was passed in the 1950s. I would agree. However, it was passed in the 1950s, and since then it has been invoked 10 times. It's been, I guess, dead for a couple of years. But now that we have the responsibility to protect doctrine, it can be used to regrow, I guess, revitalize the Uniting for Peace resolution.
But in the past, when it has been invoked as a basis for action, wasn't it usually that the Security Council itself had implied we can't come to an agreement, so, take it, it's in your court kind of thing? As opposed to this situation where the Security Council admittedly never even took it up. But doesn't that in itself signify that it didn't think, we have to give a presumption in its favor that it therefore didn't consider it, that the conditions had been met for responsibility to protect? Or is it just a kind of a pass-through, check the boxes? Look, we tried to go to the Security Council, no go, so now we'll go to the General.
This is in accordance, I agree, it's not a no-go. However, this is adopting a plain reading of the UN Charter. For example, the UN Charter provides that the Security Council has primary, not exclusive responsibility. And this was further affirmed in both the certain expenses case of this court, as well as the Israel Wall opinion case, where the court found that although the security is not exclusive. And in this case, it is the respondent's position that the three conditions to invoke the Uniting for Peace resolution have been met. The three conditions are that first, there has to be a threat to peace, or a breach of the peace, or an act of aggression. The second condition is that the Security Council. And third, because of this lack of unanimity, the Security Council has failed to uphold its primary obligation. In this case, it is the respondent's position that there has been a breach of the peace. In Security Council Resolution 84/1950, when North Korea engaged in an armed attack on the Republic of Korea, the Security Council found that an armed attack constitutes a breach to peace. And the Biological Weapons Convention, Security Council Resolution 1540, stated that the use of biological weapons also constitutes a threat, a breach of peace and security. Furthermore, in Security Council Resolution 770 on the situation in Bosnia, the Security Council found that gross human rights violations also constitute a threat to international peace and security.
Let me ask you a question. Do you distinguish at all between the two situations? One where they went in, Canada went in with your special force, or whatever you want to call it, and tried to stop the pollution, give aid to the people. But then it went on to a second stage where it went up to where the mining was going on, saw child labor, and moved to close down the mines, et cetera, et cetera. That second situation is pretty far removed from the
For the first situation.
For the first situation where they might go into, they're assuming you had authorization to go in and try to clean up the pollution, stop the loss of life. But then to go on and close down the mine, take the actions which your colleague, we won't get into them right now, is going to take us to the arrest. But that was just on the basis that there were children in the mines, children working in the mines. That's a fair stretch, even from the first part of the situation.
I'd like to turn your attention first to the resolution passed in this case stated that it called upon all member states to use all necessary means to put a halt to the humanitarian crisis. So that included the delivery of aid and disposal of the corpses.
For the moment, for the hypothetical,
Yes.
agree. What about
The second
mining?
situation. I beg your pardon?
What about the mining, the continuation by the Canadian force to go up and close down the mine, theoretically on the basis that...
In the course of their intervention, they had come across slave-like conditions, and it's also important for this court to note that slavery is considered a jus cogens obligation, and pursuant to that jus cogens obligations, every state has an obligation to prevent and put a halt to that committal. For example, this court in the case of Bosnia and Serbia stated that obligations that are owed erga omnes are owed to the entire community and each state.
But I understand in the broad theory, but let me pose, there's child labor going on throughout the world in a lot of Mideast countries, maybe even some Latin American countries all over the world. We could even extend it and say there are abuses against women going on all over the world by the national governments, yet you would extend this proposition to say we could send an expedition?
The intervention itself in this case was primarily...
It was started that way, but it was extended.
It was extended.
Does that make a situation too? A big difference, you would say you can't go in originally, but if you're there and you see this going on, it's okay to take whatever, all necessary means to stop any inhumane acts that you...
That is our position. This is in accordance with international law, because if any country went into another state because there were slave-like conditions going on, that would be deemed a unilateral intervention. However, in this case, we have a particular, not necessarily an authorization.
So you wait for a typhoon or something, and you have a good excuse to go in and do humanitarian aid, and then you can go after all the child labor in the country and all the women suppression in the country. That's a kind of a extreme.
Not necessarily, Madam President, because this is not a case of a natural disaster. It is a case where a state had already violated their international obligations under international law. So pursuant to this, the intervention was actually made. So it's necessary to read Canada's intervention within the context of the responsibility to protect against crimes against humanity and against the four crimes, in this case specifically crimes against humanity. I would like to turn to my second argument on the notion of collective self-defense. Canada's intervention is also justified pursuant to this law. There are three requirements that a state must meet in order to invoke collective self-defense. First, there must be an armed attack. Second, the response must be necessary and proportionate. And third, there must be requests for aid from the victims. All three requirements have been met. As I had indicated earlier, the armed attack in this case was the deliberate use of disease to perpetrate harm on civilians in Samutra. And this is specifically forbidden by first, customary international law, second, biological weapons convention, as well as the Geneva Protocol of 1925, which provides that the use of diseases is prohibited.
Counsel, is there any argument to be made that the fact that these diseases happened, as you alluded, was because the corpses were left there by his own admission because of a religious belief upon the person who could make a difference in there? Is there any grounds?
It is important for this court to note that Tangoon is a party to the International Covenant on Civil and Political Rights, which provides for freedom of religion. And these cannot be derogated from. Freedom of religion includes both freedom to religion and freedom from religion. And a state cannot shield itself behind freedom of religion to commit obligations that are erga omnes in nature. So for example, if one is using their freedom of religious beliefs to cause harm to another state, this is prohibited in international law. It is also Canada's position that the requirements of necessity and proportionality have also been made in this case. I will just briefly go over these because I would like to move on to my responsibility to protect them.
Your opponent, just to give you a lead on to your answer, your opponent suggested that there were things short of a forced intervention that Canada, together with Sumatra, might have done in terms of stopping the pollution from spreading into their...
Yes, it is our position that under the law on collective self-defense, as long as the victim state reasonably believes that the only way that they can repel the armed attack is through the use of force, this is sufficient. In this case, it would not be reasonable for Sumatra to prevent the armed attack, which was coming from Tangoon. The diseased corpses were originating from Tangoon, floating downstream into Sumatra, spreading diseases. So according to the, well, then they wouldn't have their water supply because both states were sharing a water table between the two states, and that might actually cause more harm, and diseases would continue to spread. This is the reason why, when Canada had intervened into Tangoon, they had burned the bodies instead of burying the bodies, because burning the bodies would rid the diseases itself. Burial might actually lead to spreading of the diseases. Okay. And it's also, the measures were used in this case. The UN Secretary General made repeated attempts to speak to Mr. Balthazar, which were continually rejected. And also, the use of diplomatic and economic sanctions would not have worked in this case because of the nature of the Tangoon ruling regime. They have a caste system on civilians, and given the exigency of the situation, to 1/3 of Sumatra would have perished if Canada had not made the intervention. So it is the respondent's position that the case of collective self-defense has been made because there was first an armed attack, and the responding force was both necessary and proportionate. I would just briefly like to talk about the legal status of the responsibility to protect, because in order for this court to apply it, it would have to be a source of international law. I see that I have just a few minutes, so I will briefly talk about it.
Just 1 minute.
1 minute, sure. The legal status of the responsibility to protect is in fact derived from existing treaty and customary international law. The fact that it speaks to crimes that are already considered jus cogens, crimes against humanity, genocide, war crimes, and ethnic cleansing, speaks to its legality. So on that note, if subject to any questions, I would just like to conclude.
Thank you.
For these reasons, the respondents respectfully request that this court find Canada's intervention justified. My co-agent will now demonstrate that Canada's apprehension, detention, and proposed surrender was also justified under international law. Thank you very much.
Good day, Madam President, Your Excellencies. My name is Dia Chopra, agent for the respondent, the Government of Canada. The respondent respectfully asks this court today to find in favor of Canada for the following reasons. First, because Canada lawfully apprehended and detained Mr. Balthazar and Mr. Barrett. And second, because Canada's proposed surrender of these individuals before the International Criminal Court is consistent with international law. Turning to my first submission, Canada acted in response to the General Assembly's recommendation to states to exercise all means necessary to ensure the delivery of aid to dying civilians and to prevent further human catastrophe in both Tangoon and neighboring Sumatra. This is in line with the UN High Commissioner for Human Rights Resolution 2001-22, which calls on all states to assist in the arrest and searching for of perpetrators of massive crimes. In this case, there were jus cogens violations that had occurred. First, with respect to Mr. Balthazar, the crime against humanity, and with respect to Mr. Barrett, the crime of slavery.
Council, can you point out for me on the record where it states that the General Assembly asks that?
It is not within the General Assembly resolution, it is within UN Subcommission for Human Rights, Resolution 2001-22.
So you agree with me that there was nothing in the General Assembly's resolution pointing out to any arrests, any sanction of any crimes, any International Criminal Court jurisdiction?
With respect to the use cogens nature of these crimes, it was recognized in the case of SS Wimbledon that while the principle of sovereignty is an important cornerstone of international law, it is superseded by use cogens. In this case, Canada's erga omnes obligation to act has been triggered because of these violations.
But Counsel, I'm interested to know how factually the arrest of these individuals was necessary in order to stop the crime against humanity. Let's use that term for the purposes of the argument. How did it assist in stopping? Why was it relevant to arrest them in order to stop?
As soon as Canada intervened, Mr. Balthazar and his affiliated Tangoon ruling regime fired against an aid convoy. Pursuant to Security Resolution 1502, this is a crime to fire against a convoy that is delivering humanitarian assistance to innocent civilians. Because of that, it triggered Canada's obligation to arrest him as a prisoner of war.
But that's a different basis for the arrest than what you were initially submitting, which was something tied to stopping the crimes against humanity. So are you saying that both were present, or that this was a matter of arresting for the enforcement aim?
It does submit that the crime against humanity initiated the intention to arrest Mr. Balthazar to prevent the further humanitarian catastrophe. However, with respect to the delivery of aid aspect of the General Assembly resolution, it was important to stop him from firing upon an aid convoy that had been carrying the necessary tools and medical relief workers and medicine to deliver to the civilians.
What about Mr. Barrett? He didn't fire any convoy, or he didn't obstruct any?
No, Mr. Barrett did not. Mr. Barrett was engaging in a use cogens violation of slavery. And as pursuant to the U.S. Ninth Circuit in the case of Unical, an individual who is a head of a corporation can be held individually liable when he uses slavery, not merely provides it, but uses it, particularly with respect to child labor.
Well, the Unical case, as I recall, was a civil case, wasn't it, under the Alien Tort Claims Act?
Correct.
So, I mean, we're talking a little bit differently about whether somebody might be held civilly liable and whether they can be arrested on the spot and taken to a ship and held in the brig for an indefinite period.
Correct. However, also under Article 25 of the Rome Statute, it provides for individual criminal liability for individuals who commit crimes within the Rome Statute. This is a treaty.
Now we're jumping over to the ICC, which we do.
However,
are you through with your defense of the, just basically crimes against humanity, not ICC?
Correct. However, it is the respondent's position that the Rome Statute is also a treaty, and so with respect to the definition of slavery, the treaty can be used to understand how slavery is defined in international law.
But what I'm not clear on is, are you saying the arrest was justified because of the slavery activity?
Correct.
Or are you saying there was some other basis, as I understood you initially, that it was to stop the crimes against humanity?
With respect to Mr. Balthazar, it was to stop the crimes against humanity. However, with Mr. Barrett, there was no evidence prior to the arrest of aiding and abetting. Therefore, with respect to Canada's arrest of him, it was purely on the use cogens violation of the Commission of Slavery.
So again, you're saying once you're in there, it's everything's open. It's all fair game. You can start arresting for all sorts of crimes that you may spot. Is that Canada's position?
No, Your Excellency. It is not the position of Canada that an individual or a state can go into another state, and arbitrarily arrest and detain. However,
isn't it exactly what you did, though?
With respect, no, Your Excellency, in this situation, and under Article 4 of the International Covenant on Civil and Political Rights, states are allowed to derogate from norms under the Convention with respect to an erga omnes obligation to protect individuals from international crimes. This was recognized in the Barcelona Traction case, that use cogens violations are not to be tolerated by the international community, and therefore Canada acted on this authority.
Suppose we found that the intervention was not justified, despite your colleague's argument. Would it be automatic that the arrests were not, could you try to justify them on some other ground, apart from whether or not the whole shebang was legal to begin with? In other words, does this part fall down automatically if we decide that the intervention was not authorized?
So if I'm understanding your question correctly, regardless of the intervention being lawful, whether the arrest could be lawful?
Right.
It is the respondent's position that first, because of the use codes violations, Canada acted. However, furthermore, when the International Criminal Court, the prosecutor issued a press release indicating that he believed and he ruled that the crimes committed came within his jurisdiction.
But the Rome statute has a very specific procedure for the arrest, and it comes not from the prosecutor. Actually, the prosecutor, normally, I guess there's some kind of provisional for huge emergencies, but normally the prosecutor has to go to the chamber and get an arrest warrant before anybody can be taken into custody pursuant to the ICC. And right here, in this case, that had not come at the time that these people were apprehended.
Correct, and for those few days, Canada does justify its arrest and its detention based, for Mr. Balthazar, based on the crimes against humanity and on the firing on the aid convoy. However, when the International Criminal Court pretrial chamber issued the arrest warrant, and that issue of arrest warrant indicates the pretrial chamber's finding of reasonable grounds to believe that crimes have been committed within its jurisdiction, that triggered Canada's legal justification to detain them until the court could take them on as surrender victims.
Counsel, I'm quite intrigued by this role reversal between Canada and the United States. So you're saying that once the ICC issues its arrest warrant, whatever has happened leading up to the arrest of this individual and his detention, it doesn't matter anymore, that the warrant is sufficient in order to allow him to be delivered to the court, regardless of how he got to that point. Is that Canada's position?
Canada's position is...
Today?
Canada did rule on the Sosa Alvarez case otherwise. However, that case can be distinguished because the individuals who were brought from Mexico were tried within a United States Supreme Court. However, in this case, Canada is surrendering these individuals before an impartial international criminal court.
Hopefully it was an impartial United States court as well, but I take it that you're saying that the difference is that the nature of the crimes and the nature of the court have an effect on whether or not the doctrine applies, and when it's in a national context, no, but when it's in the International Criminal Court. Is that the distinction?
If I understand, you're referring to the Malacaptus Beni Detentis.
Correct.
Correct. That is Canada's submission.
Wouldn't it have been better to hand them over to national authorities?
Which particular national authorities would you be referring to, Your Excellency?
Their own states?
Well, with respect to Article 17 of the Rome Statute, if we use the Rome Statute to interpret the international law, it indicates that if a state is unable or unwilling to exercise jurisdiction, then the principle of complementarity surrenders those individuals before the ICC.
And where on the record does it show that Canada made such inquiries or such assurances?
In this case, in the Secretary General's report dated May 30th, 2011, it clearly indicated that several refugees and NGOs had widely criticized the court system, the police system, and the security system in Tangoon for being impartial and for being affiliated directly with the very ruling regime that was perpetrating these crimes.
So Canada's position is that legally those criticisms gave it authority to hand over these people to whoever it wanted?
It is Canada's position that that was a sufficient reasonable basis to believe that the Tangoon ruling regime and court system was unwilling. However, it is also important to note that we ought to defer this to the International Criminal Court. Therefore, would not be for this court to determine the precise crimes, the unwillingness of either the United States or Tangoon to try these individuals, it would be for the International Criminal Court to do so.
So basically, any state or even any intervening state into the territory of another state can capture somebody that they think, or they believe is guilty, may be guilty of a crime against the International Criminal Court, and just hold them for as long as the ICC takes to do something or not do something.
With respect to Your Excellency, it would not be legally justified to detain them for several months. This was a reasonable period of time to
How long was it?
It was a period of 13 days. However, 2 days after the actual detention, the ICC had indicated, or the prosecutor had indicated.
That's not enough under the Rome statute. It's not the prosecutor's final judgment. It has to be, that's right, it has to be a decision of the pretrial chamber to issue an arrest warrant.
Correct, Your Excellency. However, also under Article 86 of the Rome Statute, it requires state parties to cooperate with the investigation and prosecution of individuals who have been suspected of crimes within the jurisdiction of the International Criminal Court. Furthermore, because Mr. Balthazar had fired upon the aid convoy during an international armed conflict, under the Geneva Conventions, Canada had a duty and a right to detain him until the hostilities had ended. The hostilities had not ended because there was continuous spread of disease, and therefore it is Canada's legal justification that this detention was legitimate in law. I will now move to my second submission with respect to the International Criminal Court's jurisdiction. As I had stated earlier, with respect, it would not be for this court to determine the jurisdiction of another court. However, to legitimize and to explain Canada's proposal of the surrender of these individuals, there are 3 factors to consider. First, that sufficient effects of the crimes took place on the territory of a state party, namely Sumatra. Second, as I had already alluded to, that Tangoon is genuinely unable to prosecute these individuals. And third, that the crimes committed come within the jurisdiction of the International Criminal Court.
What do you do with the argument, very vocally pursued by your opponents, that effects were never meant to be a criteria for the jurisdiction of the ICC?
Madam President, I have 3 points to make for that. First, with respect to the effects jurisdiction having been invoked in international law. For the former Liberian President Charles Taylor, while his commands to kill individuals in Sierra Leone were initiated in Liberia, the effects of those commands were felt in Sierra Leone, thereby triggering jurisdiction. Furthermore, the United States itself has used the idea of effects jurisdiction several times in narcotics drugs cases and antitrust law. Furthermore, the idea of an omission to act in one state, as stated in the case of Blagojevic, constitutes a crime, and the effects of that crime, if sufficient enough in another state, can constitute a crime within the jurisdiction of the court. Therefore, it is the respondent's submission that while the crime or the omission to act was initiated in Tangoon, the effect of that action was felt sufficiently in Sumatra.
But you say, then you're basically saying, just forget about whatever you call it, the legislative history or the travail preparatoire about their omitting effects in the jurisdiction. This was a crime that was committed in the name of the jurisdiction.
Correct, and it's also important to note that Professor Bassiuni, who has commented widely on the drafting of the Rome Statute, indicated that silence on effects jurisdiction does not preclude the court from invoking it. And therefore, in this case, we ask that the court recognize the legitimacy of the effects doctrine. It would be contrary to international law to assume that just because an individual is not physically, geographically within the state where the effects took place, that precludes him from being subject to jurisdiction. With respect to the issue of complementarity, as I have already stated, the Tangoon system is unwilling. With respect to the United States, if it so chooses to exercise the principle of complementarity, it may do so and can apply to the International Criminal Court for such relief. However, in this case, no expression has been made. on the part of the United States to exercise this principle. Finally, with respect to the crimes that were committed, Canada's submission and the International Criminal Court's finding was that crimes against humanity were committed on the part of Mr. Balthazar and Mr. Barrett. A crime against humanity, as defined by Article 7 in the Rome Statute, is a widespread or systematic attack directed against a civilian population. In this case, the widespread attack on the part of Mr. Balthazar was the refusal of aid combined with the intention of inflicting deadly conditions on the civilians of Sumatra. With respect to Mr. Barrett, it is Canada's submission that he aided and abetted this by drawing Mr. Balthazar's attention to the oncoming cyclone and suggesting that he use this cyclone to kill civilians. While he may not have indicated his direct intention to kill the civilians of Sumatra, it was reasonably foreseeable that thousands more individuals would have died by not warning of an oncoming, possibly deadly cyclone. Once again, however, it would be important to note that the elements of these crimes would be for the International Criminal Court to determine. For the foregoing reasons, I respectfully request that this court find in favor of Canada. It is the respondent's submission that if this is not recognized as a time for the international community to act, then we have failed in our role as a family of nations. Pending any further questions by the bench, these are my submissions. Thank you.
Counsel. You do have rebuttal from the appellants, is that correct?
Yes, ma'am.
Go ahead. How much time did they reserve? Sorry.
Hello again, Madam President, Your Excellency. The United States would simply like to rebut one of these submissions of Canada, and that is the submission of the General Assembly had the legal justification to authorize the use of force under its United for Peace powers. While the United States agrees that the United for Peace powers can be engaged where there is a threat to the peace, force can only be authorized in situations where there is an actual breach of the peace or an act of aggression committed. And the United States would like to draw the Court's attention to the General Assembly resolution that authorized action towards Tangoon. It's explicitly stated that the situation in Tangoon was a threat to the peace, not a breach of the peace or an act of aggression. The General Assembly is surely aware of the confines of its narrow applicability, the narrow circumstances where it can authorize the use of force. And had it wished to authorize the use of force in Tangoon, it would have not labeled the situation in Tangoon as a threat to the peace, but rather as a breach of the peace or an act of aggression.
Do you have any jurisprudence to back up that distinction? I understand the distinction.
While I don't have any jurisprudence, Madam President, I would submit that, or the United States would submit that this principle has become customary in international law throughout the practice of the way the United for Peace doctrine has been accepted. And again, the General Assembly is well aware of the confines of its limited authorization for use of force, and had it wished to authorize force.
And several of the people who commented in the record after the General Assembly resolution was passed seemed to indicate that any necessary means could include force. Some did not, like China and others. Some seemed to indicate anything.
Sorry, you're referring to the specific General Assembly resolution regarding the thing. Yes, certainly. So China and 29 other countries did not vote on or abstain because they did not feel that this resolution authorized force. Obviously, many more states.
But it passed.
Well, yes, exactly.
Suggestion that some people thought force was necessary.
Many other states did. The United States submits that these states who voted in favor of the resolution were not authorizing the use of force. They were authorizing means short of the use of force because we had not reached the status of an actual breach of the peace or act of aggression.
Well, they didn't say that. At least our record doesn't make that distinction.
Well, that concludes the rebuttal of the United States. Thank you, Madam President.
Do we have Sir rebuttal? 1 minute, Sir rebuttal. Pack it in.
Thank you very much. The respondents would like to waive this rebuttal, please. Thank you.
The Honorable Tribunal is now adjourned. We ask the Kings to reappear while the tribunal members complete their snoring.